Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable J.P. Cohen, Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Okay, please have a seat. All right, welcome to an afternoon session of 5th District Court of Appeal. My name is Judge Cohen, as had been announced. To my right, Judge Lawson. To my left, Judge Jacobus. We have one case for this afternoon, Nationwide Mutual versus DARRAGH. Is that how it's pronounced? DARRAGH? DARRAGH. Okay, DARRAGH. Both sides will be allotted 20 minutes each for their closing arguments. If anyone has any cell phones or other electronic devices, if you could either turn them off or silence them, we would be appreciative of that so that we do not interrupt the flow of the argument. If the appellant would like any time for rebuttal, please let me know, and I'll be glad to notify you of when that time, when you're into that rebuttal time. So when counsel is ready, you may proceed.
Thank you, Your Honors. Richard Sherman and James Sherman for the appellant. I want to thank the court for moving it to 1. I had the case in 2 o'clock in Tallahassee yesterday, so we didn't get in until about 9, so I appreciate it.
You first were not in Brooksville, right?
Yeah, right. I want to know where to go in Brooksville, at least than you here.
And you've earned your salary this week.
And I'd like to save 5 minutes for rebuttal.
Okay.
Your Honors, most respectfully, there's substantial error in this trial. The jury instruction on present value, the numerous cases say that's clear error not to give it. There are 3 evidentiary,
Mr. Sherman, what do you think the discount rate is nowadays on that future money reduction? Anybody know?
Well, the Supreme Court hasn't factored that in. They just say you're supposed to give it, and who knows what it'll be, in 5 years or 10 years, so that's
maybe
what economists testify.
Maybe a negative, I mean.
I know. But, the Supreme Court, all the cases say clear error not to give it. There's a hearsay ruling on a website that was error. There are 2 evidentiary rulings that it's hard to, seem like clearly error, impeachment with a deposition.
Are the government websites are hearsay? Huh?
Yeah, yes, Your Honor. I mean, we cite 2 cases that say.
Doesn't sound right to me. I don't know, but you think they are, though?
Yeah, we cite 2 cases because, first of all, they're hearsay, but then secondly, they say, well, this is not to be relied on. There's several factors that can affect, several assumptions, and what happens in the economy changes what happens in your career. So they're for informational, and they say something like play with it. It's just general information. And secondly, I mean, he's not an economist, so he doesn't know how to factor in what the factors are that affect it, that an economist testifies to and is subject to cross-examination. So that we say is error, and as an example of that, in his deposition, his figures, his spreadsheet was $1 million, 1.1 million more, and there's a clear $1.1 million error. And so then he corrected it at trial, so it was. Did you
all point that out to him, though? Is that what happened? You pointed out to him. He made the assumption, or he did the calculation based on he would be able to retire at 20 years when he's a reservist, and he really did start getting the benefits.
Instead of at 60, yes, Your Honor.
That's what the difference was.
So, right, yeah, but it was a $1.1 million, and so we should have been able to cross-examination.
Did you all point that out to him? Didn't you all say, look, there's an error there?
We weren't allowed to at trial. That was what we tried to.
Before trial, you told him, didn't you? I think so.
Yeah, yes, we did, definitely.
Yeah, he recalculated.
Right.
Okay.
But I mean, the point is that points out the unreliability when somebody starts doing what an economist does and doing his own calculations. We should have been able to bring out to the jury that, hey, instead of $8 million, it was only $718,000, that you made an error of $1.1 million, and the plaintiff could come up and rehabilitate him, but certainly the jury would factor that in as to the reliability of his calculations. So we think that...
Focus you on issue 2, the full value of the medical bills coming into evidence with the adjustment for collateral source after trial. There is a nationwide case, Nationwide Mutual, your same client, out of the first DCA that decided that issue contrary to your argument on appeal, correct?
I think that issue should be certified because there are 4 cases.
The question was, isn't there a case on point from the first that is contrary to your position on appeal and involving your client?
I don't remember it involving, Nationwide. The 2 in our favor are Thriasin and Cooperative v. Johnson. The 2 against us are Nationwide v. Harrell and Durst versus Henn.
Yeah, were you unaware of the Nationwide case?
No, we cited it. We cited it. That's what we say. There's contrary cases. It should be certified.
So your client's trying to create conflict in the circuits, or what? I mean,
every time they have a trial, they get in a debate about this because of the back and forth cases, and 2 of them clearly say.
You certainly didn't cite it in your initial brief.
Well, I know we cited it in our reply brief.
Well, that's after they bring it up.
After they pointed out that there was a case on
cited it in his brief.
The point is that it's your client. You've got a case directly on point against you. Don't you think that you have an obligation to the court to cite that case that is on point against you?
Well, Your Honor, I thought we had cited all cases on point. I know we did in the reply brief.
In your initial brief, you did not.
Well, I apologize to the court. It was an oversight. We cited several, and I apologize if through oversight we missed that one, but we certainly did in the reply brief. And like I said, our point is...
Now, all the cases that you say are on the other side involve Medicaid, government benefits applicable to all, correct?
No, Your Honor.
Which one doesn't involve?
All right. I believe Dursey does not. Dursey v. Henn. Yeah, Dursey v. Henn does not involve Medicare.
Was that insurance, privately procured insurance?
In other words, like I say, there's a conflict with authority.
I don't think you heard it.
Was that privately procured insurance at issue in Dursey v. Henn?
I'm sorry?
What was the collateral source or arguable collateral source?
I believe in Dursey, he paid it himself. He negotiated it down himself, and the court said since he did it himself, this was like he got some benefit of it. The last paragraph is on 5 on page 7. Reduced by the medical, he received treatment. He did not have health insurance. He did not pay premiums, but he negotiated a low amount, so he earned in some way within the meeting of Nationwide the lowered final amount of the medical bills. So like I said, there's definitely...
Was that the case that was consistent with the Nationwide holding?
Yes, Your Honor.
Okay, I was asking on the other side of the issue. You say that there's a split, but...
All right, the 2 in our favor are Thriascup, however you pronounce it, the Thriascup Elevator versus Lasky.
And those were Medicaid benefit cases, correct?
Yeah, they did not hinge the opinions on its Medicare, but then when the other cases distinguished them, they said as Medicare. But they didn't say the reason we're ruling it as Medicare, but then when the Harrell case distinguished it, they said because it's Medicare.
So there's no direct and express conflict at all?
Well, it depends. I mean, they didn't say the reason we're ruling it as Medicare. I think that, I just think there's confusion. All the trial attorneys go there and have to argue it, and it would be good to certify conflict because there's not a clarity.
Well, if we agree with the distinction that's drawn in the Harrell case, and see that the cases are distinguishable, why would we certify any conflict if we followed?
Well, I just think it'd be good to have the Supreme Court speak so trial attorneys don't have to keep arguing. Right now, there's, the second, fourth cases in second and fourth one way, cases in the first and fourth the other way. So I just think in a situation with every trial that comes up, it'd be good to have the Supreme Court speak. So that's our position. If you think it's just a matter of writing an opinion, that's certainly your honors are the judges, but I just think
except for that issue, the other issues you raise have to do with economic damages, correct? Error that would have affected economic damages.
Right. Errors that, the reduction of present involves $1.5 million of future economic damages, and we continue. Also, there's another $800,000 of future pain and suffering. We know juries use economic as a gauge of the pain and suffering, so there should be a new trial on everything. The Supreme Court
if the errors, I mean, there are cases that are all over the place with that, but if the error only affects the error that you allege other than issue 2 or argue only affects economic damages, why would we send it back for a trial? Why would we have the jury look again at non-economic damages?
Well, first of all, I don't believe that the Supreme Court cases on instruction reduction say you just do on that one issue. But then secondly, they're intertwined. Like I said, the juries use economic as a gauge of.
That's in the jury instruction, is it?
Pardon me?
That's in the jury instruction?
No, it's not. But I mean, everybody. That's just the way the practice works. Is that everybody you settle based on some ratio of the economic that it's factored in. So with that error, and then plus once again we have the other error, the spreadsheet. We cite 2 cases that say that websites are not
Let me ask you specifically about this case. Do you recall? Does the record reflect that there was an argument linking or asking the jury to link the amount of non-economic damages to the economic damages?
No, there was not.
Okay.
No. I'm just saying it's the common sense. The plaintiff's attorneys and defense attorneys that handle cases, I mean, people know that that's a kind of a ratio that they factor in. And then on the spreadsheet, once again, he did a spreadsheet. They testified from. He's not an economist, doesn't know all the factors. The website said there are various factors that could apply. Submitted that as error, and then when he made an error of $1.1 million, I mean, we should have been able to cross-examine. That's an indication of the lack of reliability. So we just think, I think these are clearly errors. These last 3 hearsay and then the 2 evidentiary ones about the spreadsheet. So there's error throughout the trial, and since the fairness is just.
Let me ask you this: now one of the arguments is that it was appropriate to take judicial notice of the statutes upon which the formulas for calculating retirement benefits are based, and you would agree that generally, if the formula is in the statute, there's nothing wrong with the trial judge taking judicial notice of those statutes, correct?
I'm sorry. Could you repeat that?
The formulas for calculating retirement benefits are set forth in federal law and statutes, correct?
I don't know. I mean, I'm sure there's. Once again, like it says, there are factors.
Was there a request at trial to take judicial notice of the statutes?
No, to take judicial notice of the website. I believe that was just to take.
He did take judicial notice of the statute, I believe, the federal statute.
But at any rate, what we're objecting to is a website. A request for judicial notice of military benefits is in our appendix, and he attached the website, and the website says there are various factors. What happens in the economy? What happens in your career? Other factors. It says, play with it. It's some general information, though, but do not rely on it. So we just think it was under the wording, and they haven't cited any cases that say you can just put a website, and we cited 2 Department of Corrections cases where people try to put state of Florida websites in, and the court held that was reversible error. I'll save my time for rebuttal. Thank you.
Good afternoon, judges. Attorney Jeff Bird, also the trial lawyer in this case. I'd like to spend the bulk of my time talking about the thing that causes me to lose the most sleep, which is over this present value issue, but if I could just have 60 seconds to address this last issue regarding websites. Nationwide keeps continuing with this notion that these websites were introduced into evidence. There was a hearing a week before the trial, a motion for judicial notice of the formulas necessary to arrive at the calculation.
Those statutory?
Correct.
Federal statute.
There was a website that was relied upon before trial, but there was so much cane raised over that website that the whole thing got scrapped in exchange for an Excel spreadsheet, which was nothing more than the simple mathematical formulas of his age, rate of pay, times a constant, which Congress has always enacted to be 3.0.
Is that argument a joke?
By me?
Yeah, now, when I asked you that question, you'd probably say, what kind of question is that, Judge, right?
I'm sorry.
If I asked you a question like that, you would rightfully say, what kind of question is that for you to ask? You're taken back by that question, are you not?
Yes, sir.
And you wouldn't think that's a very professional question of me to ask, would you?
No, sir.
And why would you put in your brief comments like, is this claim of error by the trial court a joke? Why would you put in your brief language like, that is pure silliness? Why would you put in your brief your use of bold, of multiple question marks, multiple exclamation points? Are you like you're yelling at us or something like that? Do you think that that's professional in terms of the way that you wrote this brief? And I'm speaking for myself now, not for the other members of the court. Do you think that that's a professional method of writing a brief?
Whatever argument I was advancing at the time, obviously I had a reason, and I felt that their continual...
I'm asking you if you think that that type of language is professional.
Perhaps in hindsight, I guess not.
Now, I'm going to suggest that I don't think it's professional, and I have some issues with some of the things that you've done in that brief. Remember, we're not involved in the emotions of this case. We are looking at it with a record, just a cold record, and we're looking at it dispassionately. That is the method that we are, and all of us, whatever the panel is, that's how we're going to look at it. I suggest as a advocate that you try to do the same in the formulation of a brief. It does your arguments no good to use hyperbole and language such as was contained in your brief. So now that I've said my piece on that, let's go and let you get through with your argument, and I'll give you an extra couple minutes if you need it, because I've taken up this time to talk to you about it, okay?
I appreciate it. Thank you.
Okay? Is that okay?
Thank you.
Alliteration is that's good.
As it relates to the website, I think a careful review of the trial transcript will show that the website that previously had been referenced wasn't even the computer. The government has the ability to create a similar type spreadsheet because it's a simple mathematical formula. That got scrapped for a simple Excel spreadsheet, which my client was well qualified to prepare, in as much as he's a professor, and that's part of his teaching of college students how to do a simple Excel spreadsheet. So I keep hearing references to this reliance upon a website, but that's not an accurate statement of what occurred at the time of trial. There was also references to the inability to attack the plaintiff based upon prior inconsistent deposition testimony. They are the ones that brought to the attention of the plaintiff the flaw in reliance upon the website, and indeed they were accurate. So indeed, based upon that, there was $1.1 million saved to Nationwide, when indeed it was correctly applied as of 60 years old as opposed to upon 20-year retirement service. And that was an important distinction that was brought to everybody's attention. It was corrected. So the court, the trial judge, said, for purposes of this trial, you will impeach the plaintiff based upon the evidence that's presented, not impeach him based upon outside evidence that the jury hasn't even heard. Let me talk about the present value.
Just so that I understand,
Okay.
where can I look to find, because I had a hard time with it, the statutes that were taken, of which the judge took judicial notice, and in those statutes, the easily applied formula that your client could just simply put into an Excel spreadsheet to get the number that he got?
You asked me a good question that I've left the data over my table, but I know that there were essentially a few figures that were important to know.
Go ahead, get it if you need it.
Okay. There was a lengthy hearing on a motion for judicial notice as it relates to the military benefits, and there were multiple, differing statutes, because you got to look at the rate.
Do you know if that hearing's transcribed, is that in the record, do you know?
It's my understanding that that was
Okay,
provided.
okay.
Yes, sir. It's my understanding. And there were a variety of, to answer your question, Your Honor, there's a 10 USCS 1406 and 3633 that sets forth a service member's retirement benefits and the methodology for computing whether they are retired, from their point of retirement. There was also a defense, finance, and accounting services, the accounting firm for the U.S. Department of Defense, that sets forth the criteria as to the, I don't know that inflation is the proper terminology because that's not what Congress calls it, but servicemen are given a pay rate.
Cost of living?
Essentially, yes.
Oh.
It has the ability to fluctuate, but historically it has remained steady at either 3.0 or 3.5. And when Mr. Darragh did the calculations, he took it at the least amount that the Congress has ever increased it to be.
Have you provided all the statutory references?
Yes, sir.
Okay, thank you.
But I would like to spend some time talking about the reduction of present value, because in review of the brief, a case came out after trial, which does cause me to lose some sleep in candor to the court. The Milton versus Reyes decision came out and did say that it was error to fail to give that instruction. Now, I've reviewed it and reviewed it and reviewed it, but Milton, unfortunately, is very brief in its facts. It was decided several months after this case was tried. So,
But there was plenty of law before this case was tried that said it was error not to give that instruction.
yes, Judge Cohen, and that was based upon a statute that I had presented to the trial judge. It had been changed
I
in
know the
1999.
argument that you've made. We've read it. Yeah.
Okay. And candidly, the jury instructions, I was part of another case that went up to the Florida Supreme Court where there was a jury instruction relating to set off of PIP benefits that was an inaccurate statement of the law. I find no fault with the committee. They've got a job to do. But oftentimes, there are changes in statutes that aren't reflected in the instruction until a case like this
Well,
goes to the
let me
Supreme
ask you,
Court.
isn't this is a common law requirement? I mean, that jury instruction was in place long before 768.77 was even enacted. So
I will candidly tell you I looked for that.
Yeah.
If Your Honor found something that said common law, you found something I did not.
Okay.
I will just honestly tell you, I know I have to acknowledge both sides of the case, and I didn't
The common law
find...
required it. The common law required the reduction of present
and
value.
it looks to me, and tell me if you think I'm wrong from reading the statutory change. The statute simply said that you had to, the jury form had to make the calculation on the form.
Right.
It had to show the future value or and the present value.
You had to
and
show the
it was
future
that
value.
requirement to separate it out.
Right.
That was the amendment, that they took out the requirement to separate it out. But there was not, generally, if a statute's going to change common law, I think the law is clear that it has to clearly and explicitly do that. And if this was a common law requirement, I have a hard time understanding how that statutory change would have affected the common law requirement.
I would agree with Your Honor. I did not find anything that said it was common law. I'm just being candid with the court. I did not find that. That doesn't, I'm not here to advocate that it doesn't exist. I did not find anything that stated in the common law. In fact, I think that the first Florida Supreme Court case that addressed that, I want to say had its origins in the 1950s, and if it had truly been common law, it would have well predated the 50s.
But I mean, there was no statutory basis for that 1950s decision. I mean,
Right.
it was...
They were fixed, you remember the verdict form used to say future value,
I do
number
remember
of
that.
years, and it was just a nightmare. Juries didn't understand it, and they took it out. I mean, that's kind of what happened.
They did, and the verdict
That
form...
was the change in the jury instructions that you read in the note. They were changing the verdict form, but not that you didn't reduce it to present value. You just didn't make the calculation.
What's the standard of review in our determining whether a trial judge committed error in failing to give an instruction like this? In this case,
The standard review would be error. I think the question you might actually be asking me is what would be the remedy to fix the error?
No, I'm asking, generally, we have a de novo standard of review. If it's an issue of law, abuse of discretion standard of review generally applies to the giving of jury instructions, or in some cases, we're looking at a competent and substantial evidence standard of review. So
It appears to be that the standard review is error. It appears to be.
There is no
that's
standard of review called
To be
error.
I suspect to be de novo.
I'm sorry. That's from the Milton case, I know that they also based it on error, not a discretion.
It was error not to give it.
Correct.
But does the judge have discretion, or, is it abuse of discretion, or do we look at it just like the trial judge did?
Herein lies I apologize. Herein lies the difficulty. In this case, there was no evidence as to what that amount is, and Your Honor brought up earlier, what is the discount rate? And it probably is a negative number now.
That was just...
Well, and it is because the cost
the discount, if we understand how the math works.
Correct.
I mean, the discount rate is minimal.
Right.
Now,
Which is why the committee, I felt that their notes were worthy and were brought to the trial judge's attention, because the committee notes say it's still, until such time as the Supreme Court or the legislature adopts a method, we'll leave it as a matter of argument. Well, the legislature omitted the requirement based on the statute for a jury verdict. And I understand you're talking about the format of a verdict, but I respectfully...
Still, you put, it's still, as Mr. Sherman points out, even though, there's nothing about the discount rate in the comment, that's how you do it, that you get the instruction, because it's got to be reduced.
But was it factored into the judge's decision that there was no evidence whatsoever that would aid the jury in making that calculation or explain to them how to do it?
There was, but I could not, as an officer of court, tell you that that should be the sole basis, in as much as I know that there's case law that has said that even in the absence of that type of expert testimony, you still give the instruction. The statute appeared to have changed. I understand the premise is, well, that's because the format of the verdict changed.
That's exactly what it is.
Well, it doesn't expressly state in the statute there's the format in the method that I know Your Honor is familiar with, where they had the blank lines that you fill in.
Because that's what it used to say.
I recall those days as well.
That's what the statute said. You had to do it that way.
Right.
Yeah.
And it's interesting because the verdict form did change, obviously, to reflect that change in the statute, but yet the instruction that is what gave rise to the explanation for the verdict form.
That didn't change. Still, you reduce future economic damages to present value. It didn't change anything.
Well, I understand.
Let me ask you
this:
if we determine that it is reversible error not to have given the requested jury instruction on reduction to present value, and we determine that that's the only error, what do you think the remedy should be?
Well, I've also given careful thought to that. Here's what I view it as. We know that the verdict of almost $4 million, that 1.5 related to the future economics. This jury instruction would relate only to that aspect of the damages, which means the jury's verdict is solid as it relates to the other 2.5. Keep in context that this is a case where the verdict, whatever it ended up being, was reduced to the policy limits of $200,000. We're not here in a bad faith setting. When a bad faith case...
We're getting there, aren't we?
We will one day, but when that case is litigated, there will be far more at stake in terms of damages than just even the verdict. A lot more extra contractual issues. Getting back to just that component of the bad faith case being the verdict, that the judgment that could have been entered but for the limitations of the policy, If one were to fix it, Nationwide takes the premise, well, we have to retry the entire case. Even the Milton case says, no, you just retry the future economic damages. I take the point of view as an advocate for my client that we already know the full value is to be 1.6 based upon a presentation of all the evidence during a one-week trial. The jury made that calculation. Is there a method or possibility that could, if it needed to be, based upon the ruling of this court, to be remanded, could there be some form of like evidentiary type hearing like you would do for post-trial collateral source set-off? I would anticipate Nationwide would...
You didn't do that either in this case, did you?
I'm sorry?
The collateral source set-off?
That was done post-trial, sir. Yes, sir.
I must have missed it then.
It was done post-trial at a hearing held almost a year after the verdict, and that's what gave rise to the judgment that was finally entered for $200,000.
Well, I saw the judgment for $200,000. So,
and contained within that judgment was language as to what the judgment would have been but for the limitations of the insurance policy.
Right, but didn't that have just a basic amount? Did it set out, did it reduce the medical bills?
Yes, sir. It was reduced by the amount of...
By the amounts paid by the collateral source.
Yes, sir.
All right, I missed it. Okay. I missed it.
So getting back to potential, if this court were to determine that there is error that requires some sort of remand, number one, we could have a jury in literally a 3-hour trial determine of the 1.6 what would be the reduction of present value. If Nationwide's position was, well, there's a demand for a jury trial, so we couldn't do it in an evidentiary setting. That jury doesn't need to hear the totality of a week's worth of evidence to determine if the 1.6 is appropriate. Their sole job would be to determine of the 1.6 that another jury has already determined based upon a presentation of all of the evidence, what would be the discount, if any.
How would, as a practical matter, I'm struggling with how they would do that. I mean, you sort of have to know what the jury had in their mind in terms of, you know, what did they believe the lifespan to be, and what they, you know, because you have to have numbers to fill in, and I don't know how, I mean, other than they have a lump sum, but I don't know how they would know what the jury was thinking in terms of how those dollars added up in the future, over what sum of years. I mean, I don't know how you do that.
Well, and that's why I say it's a distinction between whether we retry a 5-day case to have that all put in context or just a couple-hour case to have somebody. I mean, in an ideal world, could Nationwide have hired an economist and had somebody come in?
If you retry it, it's because you walked this judge into error.
I hear what Your Honor's saying, but for the apparent change in the statute,
Not on purpose, right?
well, I don't know that anybody would want to do that, especially with a $4 million outcome. But for the Milton case, I feel strongly that based upon the change in the statute, the court gave the instruction based upon the current state of the law. And keep in mind, too, that was after the legislative intent was also provided to the trial court judge, who had an opportunity to review that. And the legislative intent is also crystal clear that the legislature chose to withdraw from the jury's consideration this issue for the sole purpose of simplifying the jury's deliberations. Because we had these conflicting cases before that talk about the differing methods, the total offset methods. It's causing confusion. Then you have this case like the DARRAGH case where there are no economists, there are no experts.
So you're still arguing that there was no error?
I am, but for the Milton case, which I have to agree, the Milton did come out after the 1999 change. All of the other cases respectfully predated the 99 change, and I would agree that based on that statute as it existed then, that is what would have been done. If Your Honors have any further questions, I'd like to be able to address them in the last minute and a half. I hope that the positions were well articulated in the brief, but for some of the language. And I thank you for your consideration.
Let me ask you to make sure I'm clear on that. At the end of the day, on the military retirement, what you did is you used the statutory formula, right? The court took judicial notice of the U.S. code that had the formula. Your client then put that into an Excel spreadsheet and got his number.
Yes, sir, and it was very simple math.
He's a professor?
He's an adjunct professor.
And he teaches Excel, is what you're saying?
Indeed.
Did the jury know that, or the judge know?
Indeed, that was also told to the jury.
Thank you.
But he's not an economist.
Correct, and I don't know that there's any case law that says an economist was needed to do, which is simply, it was no different than a times table.
Yeah, okay.
Literally, it was that simple. Thank you.
All right, thank you.
Your Honor, I found why we didn't cite Harrell. It came down after we researched and wrote the brief, although it was 11 days before we filed it. We didn't, if I had known, I would have cited in our reply brief. We admit at some point. We just didn't know about it, Your Honor. I'm sorry about that. Being a professor of Excel is different from being an economist. And secondly, he didn't ever testify. He looked at the government statutes as to what it was. He looked at the website. And that's not the same thing at all. And the website says not to be relied on. And many factors apply. So that's not.
Let me ask you, what I'm struggling with, and I understand the case law, but why the failure to give the instruction on reduction of present value is harmful error in context? I mean, for one, you gave the jury no testimony on which they could make that calculation. I don't know what they would have done with the instruction if you'd given it to them. I understand the case law on that. But number two, we know that given today's the economy today, that it would be negligible. I mean, I don't even know that there is a discount rate.
Today doesn't mean what it's going to be 10 years from now. Interest rates.
But the discount rates today.
Pardon me?
The discount rate you would use is based on,
In other words, the economist comes in and tells us what today the discount rate is to determine, present value of future money.
Yeah.
in other words, I can understand the rule that if a party requests that instruction, they're entitled to it in a case where the discount rate would be such that it would make a difference in the verdict, and particularly where they would give the jury that testimony that would allow them to actually make the calculation or do something with it. But in a case where the discount rate is such that it really is not going to make much difference, if any, and where you gave them nothing on which to make that calculation, I'm just struggling with why, in spite of the case law.
I don't know, the Supreme Court has never said those factors are involved. It doesn't say we only give it if the discount rate is over so-and-so. They just said, they didn't say you only give it if those economist testifies. They just made clear any time a party requests it, they're supposed to, or it's reversible error. I mean, they've never, I understand your argument, but the Supreme Court's never said only above a certain discount rate. They've never, so we think it clearly was error.
What's the harm in this case, as Judge?
Well, I mean,
you got a discount rate that's probably substantially less than 1%.
Well, I mean, it's $1.5 million that you reduce the present value,
I would think that if I were hearing from economists, the economists would say that healthcare rates have outpaced inflation,
right?
And that's expected to continue. So it might be, at least to the health insurance, the health costs, it might be a multiplier, not a subtraction.
Well, I mean, that's an argument, but that's something that's cross-examination. But I mean, it's not something you say, well, the jury knows this and the jury knows that, and they know what the
there was none of that in the trial. There's no evidence in the case that has any of that. In other words, you mean the instructions at the end. What evidence did anybody put on about anything?
Well, I mean, the Supreme Court doesn't say that it's only to be given if an economist testifies. It says at any time it's requested. I mean, the Supreme Court, chooses its words. It says any time a party requests it. So I just, think that they've made clear that is the law. And once again, the spreadsheet, we cite two cases, Campbell and I forget the other one, but that say that it's error to allow an unauthenticated website. That was from, state of Florida website. And once again, what's the reason?
Now, to clarify that, your position is that the plaintiff went to the website and based his calculations upon the website, not upon the statutes. Is that your position?
Well, no. All right. We have like three. Number one, he used the website, which it specifically says don't
Let me ask
use.
this, was the website placed, copies of the website, were they placed in evidence before the jury?
I believe so. I'm not certain, but I believe it was. He definitely, it was definitely cross-examined. It was brought out what it says, but it's, I don't recall specifically it was placed in evidence. But I mean, so that's number one, that he used it in the first place, and it says it's not reliable. It depends on various assumptions. You don't even know what the assumptions are. And number two, he made a spreadsheet from it without knowing what assumptions affected and with not being able to cross-examine because he doesn't know. And then number three, when we impeached with his spreadsheet from the deposition was off by 1.1 million, we weren't able to impeach with that, and that would have made the jury wonder whether it was accurate. So we just think there are multiple errors, and especially the reduction, so we think it should be a new trial.
All right, thank you.
Thank you very much, Your Honor.